So welcome. I know most of you, a couple new faces. My name is Kim Purdy, and I am, this is an office that I work at. I'm a licensed real estate agent here in California, but mainly I focus in the LA and Orange County area. I have been doing these events called Real Estate Conversations for the past, about 8 months now. Pretty regularly. I took a little bit of a break around the holidays, but my intention with hosting these events is to really just provide a space where we can all have conversations around all things real estate related. So often in life we come across people and we build relationships. And some of you know that my background for many, many years was teaching yoga. And one of my friends during that time said to me, have you ever thought about getting a real estate license? And I just thought, you know what, that would be kind of fun to do. It'd be fun to learn something new. Never did I think I would actually become a licensed realtor. Never did I think I would be making my own investments and growing a portfolio and being so inspired by real estate. What I love about our community and our relationships, I mentioned that word earlier, is getting to know one another. So this group, the Real Estate Conversations, is ideally going to become more of a collaboration as time goes on. So many of you have come to my events before, and I love feedback where you say, you know, I really want a trust attorney to come in and speak one night. So I get a lot of the information from you guys and what it is that you want, and then I just hold the space. So as I'm holding this space tonight, you'll notice that I've got a few things that are up here that I just like to kind of lay out for all of you guys. Like, everybody is welcome. So if you come to these events and you're like, hey, my friend Claudia would really love this event, I'm gonna invite her, please do. Some people are investors that come in here. Some have never purchased a home before. Some are, thinking about maybe 10 years from now I wanna purchase a home. Others of you may be looking at selling, whatever it may be, or maybe you have no interest in real estate whatsoever, but you're like, my parents need this information. So whatever it may be, everybody is welcome. And this is a place, I call it a sangha. It's being together. It's a community. It's a space where we can all come together, ask questions, and learn from one another. So these are just a few things that I've put out there and that I want to infuse into everything that I do. And that is the reason why I'm so excited to introduce Ariane Sims, who is our guest speaker tonight. Yay! So she's going to give you her card at the end of this, and if you look through her website, so much of what I just said is infused into what she does. And that is, it's like who we surround ourselves with really matters. And when I found you and when I heard you speak for the first time, I was like, oh, we have to do this. We have to do this event. So many people with trusts, they think, oh God, I don't want to think about that. I don't want to think about dying. I don't want to think about preparing for the future, because that's a little scary to do. And I know when I did my trust with my wife, I was like, oh, I don't want to think about somebody else raising my kids. You, at least from the presentations I've seen you do, and then also your website, have really put it out there where you're like, it's not just about when that happens, it's about now and how we can plan and be educated for what's going on in our lives in the current moment. So I'm going to let you take it away. I'm going to pull up your slides, but
okay.
Thank you.
Thank you. No, huge thank you, first of all, to inviting me to be here with you all. I loved sharing this information, and also for that breathing moment. I mean, I've been running like back and forth crazy all day, and it was so helpful to me. I can only imagine. So thank you for being you, for having this community, cultivating this community. And I'm excited. Do you guys just want to quickly go around and say your names? That would be really nice.
I'm Matt.
Miriam.
Alfredo.
Racy. Sylvia.
Jen. Dana.
Janine.
Richard.
Julie.
Robert.
Claudia.
Dan.
Cynthia.
Michelle. Brandy.
Okay, great. Thank you all. In terms of Roger, sorry. Sorry. Just in the spirit of cultivating community. Some of you I know, some of you I'm so happy to meet for the first time, and I really welcome you afterwards, and we'll talk more about it, but come up to me, I'm happy to chat at any point. Okay, so we'll get started. So why every California homeowner needs a living trust. And the footnote to that too is as part of a more comprehensive estate plan, and I'll touch on some of the other pieces, but the living trust will be sort of the foundation or centerpiece of the conversation. So we can go on to the next slide. Thank you for doing this. So for those of you who've seen me present before, I always start off with pictures of my family. That is my son Mateo and my partner Milos. And the reason I start off with this is they are the reason I do what I do. I used to do a lot of other things. I worked at a big law firm in New York and LA. I worked on a reservation doing legal services in New Mexico. I left law for a while to do media, environmental media. But when I was pregnant, I started to think, oh, I got to do some adulting, right? And I thought, well, I've got to look into this estate planning stuff. I, studied it for the bar and things like that. And when I did, my mind was blown because I forgot, or maybe never even knew, the extent of how important it is, particularly here in California for reasons I'll talk about. But also, not only how important it is, but also that so few people actually know what happens when you don't have a plan in place. And so I said, you know what, this is what I'm going to do. This is my mission. I'm going to take my legal background and my love of working with people and do estate planning to help them. So I thank you to my family for me finding what I love to do. So we can go on to the next one. So my question to all of you to ask yourselves, and keep thinking about this through the presentation and beyond, who do you love the most? Is it your kids, your dogs, your partner, your parents? And just think about that. And then we can go to the next slide, because they're why we plan. It's not really for us. And yes, there are things about planning that are for us, but it's really about the ones we leave behind if something happens, both short-term and long-term. And the question is not only who do you love the most, but what do you want to leave them, right? Do you want to leave them with court and conflict? Or do you want to leave them peace, ease, love, personal legacy, all these things? Obviously, the latter is the choice that I think most people would make. Okay, so let's go on to the next one. Okay, so these are the topics that we're going to talk about today. One, what is probate and why is it so terrible? Two, how does a living trust actually work? And then three, we'll talk about these a little more peripherally, but I think they're really important to touch on. How can you ensure your kids are always safe? And how can you leave a meaningful legacy behind? Okay, so we can go on to what is probate and why is it so horrible? And to the next slide. Thank you so much. So.
It froze. Hold up.
Well, I can start talking too.
Okay.
So probate is a really dirty word, but a lot of people don't actually know why. Perfect. And these are the reasons why. Number one, so every state has probate, but California is the worst for these reasons. And let me just take a step back of what probate is for those of you who don't know. Probate is the court process that when you pass away, your loved ones have to go through in order for your assets to go out into the world, to be distributed to your heirs. And probate is terrible in California, particularly because, one, it's really expensive. There's statutory fees and costs that bring the cost of probate to about 5% of your probatable estate. Now, this is the kicker for a lot of people. When I talk about the probatable estate of your assets, we're talking fair market value, okay? So say you purchase a house, $1 million house, and you put $10,000 down. That house is going to cost about $50,000 to probate, even if you have $10,000 equity in it, okay? And then add another property. Some people have more than one, bank account, all those sort of things. And we'll look at some numbers in the next slide. So probate's super expensive in California. Number two, it can take about 2 years for your assets to be distributed to your loved ones, okay? That's a really long time. And this is an uncontested probate, okay? When there's a contest, forget about there being a contest. So it just takes a long time to wind its way through the court system for hearings, all the things, okay? And COVID even backed it up more. And then finally, probate matters are open and public. They're public record. And so if you have young or vulnerable beneficiaries, people will prey on them. It's terrible, but it's true. So for all these reasons, probate really is as horrible as the dirty word is. Let's go to the next slide and we can look at some numbers just to get a sense of it. So When I do planning sessions with clients, I have a chart that looks like this, and I use their specific assets. These are just, numbers that I chose for the sake of giving an example. We'll talk about estate tax very briefly, because a lot of people do always ask, is there an inheritance tax, estate tax? What is that all about? Well, California actually doesn't have a state estate tax. Other states do, but we go by the federal estate tax, and it's 40%, which is huge. But you're only taxed on the amount over whatever the federal exclusion amount is at any time, and that number changes. In the not too distant future, it was like $1 million. During the Obama era, it was like in the $5 million range. Trump bumped it up to 11. Every year it's adjusted for inflation. It's currently $13.5 million a person. So right now, unless you have over $13.5 million a person, you're not going to get, your state's not going to get taxed. That number will sunset in 2026 back to, probably we're guessing around 6.5, 7 million. So a lot of people don't have an estate tax issue, but it's just something to know, and I just wanted to give that little bit of tidbit because people often ask about it. And one thing I just want to notice, I mentioned fair market value. On estate tax, you're not taxed on your debt, so we only look at the equity that you have in property or other assets. Okay, so let's go back to the probate column. So we look at the fair market value. And you'll see all those assets are listed. Now, retirement and life insurance, if you have an adult living beneficiary, those pass outside probate, and that's why they're not in that column. But if you name minors, and I see this a lot, where spouses may be named primary, minor children or contingent, or if you're only a single parent, they'll name minor children, then you're going to get the court involved, okay? So it's just something to keep in mind. So for purposes of this, we've got a probate estate of 1.75, you know what I mean, 1,755,000. So we can go to the next slide. The cost of probate for this couple or this person is going to be close to $90,000. That's how much is going to be taken out of the estate to cover court fees, lawyer fees, administrative fees, all that. It's a lot. And you're going to have probably 2 years of public court proceedings, and then some additional costs that are involved, maybe not monetary costs, but potential family conflict. You'll have no say as to who would make medical or legal or financial decisions for you if you were incapacitated. If you have minor children, you'll have no say as to who would raise them. A judge is going to decide without any input. And sometimes the person who looks really good on paper to the judge is the last person you would want. I've told this story, some of you may have heard it. I know somebody who had a sister and a sister-in-law, and on paper, the sister-in-law, had a stable job, had children of her own. She absolutely seemed like the right person. Totally toxic household. The people she would never, the sister-in-law, she would never want her sister had a very bohemian lifestyle, traveled, didn't have a partner, but was absolutely the person that she would want raising her kids. So that's a perfect example of why it's so important to have some say and agency over that. And then the other thing is, again, if you have minor children, if you don't have a plan in place, or even if you have a will, the court will manage, because kids cannot legally inherit assets. So the court will appoint somebody to manage the assets for them, and then at 18, they'd get it all. I know people, I don't want my son at 18 getting a life insurance policy. He's not going to make good choices with it. I wouldn't make good choices with it at 18. And so those are the things these are the costs of having no plan in place. But we can go on to the next slide. So a question that comes up, but the good news is we can avoid all those things. The question that comes up a lot is the difference between a will and a trust. In the movies, we always hear about wills. You don't always just hear about what do the trusts say? It's usually the will, right? Well, a will simply tells the judge who you want your assets to go to. It doesn't avoid probate. It still has to go through that system. And the idea is that the judge has to stand in your shoes to sort of sign things off. And some people say that probate is the lawsuit that you open up against yourself for the benefit of your creditors. A will doesn't avoid probate. So a will, especially here in California, is just not enough. So a trust, so the answer is clear. So we can move on, and I'll talk about how a trust works. So I love to use the analogy of a wagon, okay? So during our lifetime, we wield a wagon, and whatever we put in that wagon is protected, right? And I'll talk about what we put in. And then if something happens to us, we become incapacitated or we die, we drop the handle, the person we name as successor trustee can just pick up the handle of the wagon and keep going. No need for court intervention. And the reason for that is that the assets are held in trust. So whoever is the acting trustee has authority to manage those assets for the benefit of the beneficiaries, okay? So the things that we put in the trust are real property, cash accounts, non-retirement investments like brokerage accounts, and then if you own a business, we can assign the business interest because those are the assets that are going to go through probate, okay? And the way we do it is really simple. I like to sort of say we're taking assets out of our right pocket and putting them in our left pocket and just calling them something different. So instead of owning my house as Ariane, I now own it as Ariane, trustee of the Ariane Living Trust. And we record the deed and it's in the trust. Obviously, we have to create the trust. Same with bank accounts. You go to the bank, you retitle the accounts. Non-retirement investments, same thing. With respect to retirement and life insurance, those don't go in the trust, but we can name the trust as the beneficiary. So for life insurance, even when there's partners, I recommend that the trust be the primary beneficiary of life insurance, because if something happens to one partner or spouse, it's there in trust for the other. And if something happens to both, it's in there for the minor children or the other beneficiaries, whoever they may be. Retirement, there are tax benefits to naming each other, particularly spouses, as primary beneficiary. But again, if they're minor children, we can name the trust as the contingent beneficiary. Or for single parents, the trust is the primary beneficiary for the retirement. So it's really like a funnel that everything's going through for the benefit of the beneficiaries without the need for court and judges and delays and all the hassle associated with probate. Okay, we can move on to the next. Okay, a couple other reasons why living trusts are the clear choice beyond just probate. So they offer a far superior way of leaving assets to minors, young adults, and those with special needs. What a trust allows you to do is dictate ages or stages at which your beneficiaries can have access to your assets, right? We don't want minor kids inheriting at 18 or young adults. You know, a typical scheme would be at 25 they get a portion, 30 they get a portion, and at 35 they get the rest. We can even leave assets in trust for their lifetime and beyond. So if they were to ever get divorced, those assets aren't in their name. They're more protected from creditors, bankruptcy. There's all these tools we have to protect inheritances in our beneficiaries, both the assets both for and from the beneficiaries, right, when they're too young or if they're not responsible. The other thing is if you have beneficiaries with special needs or anybody that's getting needs-based benefits, if they receive inheritances, they can lose those benefits. So we want to make sure that we leave assets in a trust that's specific for those with special needs, and they're administered in very certain ways, following laws and regulations. And then that's also what I was talking about, that you can provide lifetime protection from divorce, creditors, bankruptcy by leaving assets in a trust that continues on, which is a really, really great gift, I think, to our beneficiaries. Okay, so estate plans need love too. So I have seen, I work primarily with parents with minor kids, but I do work with lots of other people. And oftentimes what happens is I work with a young family and they say, you know what, our parents have an old trust that is really old and it really needs to be reviewed. Well, 30 years later, they've acquired real property in other states. They would have had a probate in every state. They had the trust. They did the right things to fund it in the beginning, which not everybody does in the first place. But even if they did, all these later acquired assets were never in the trust. So people have created the trust, done the right thing, and their loved ones would still be faced with probate, and potentially more than one if there are different states involved. And so we want to make sure that for all these reasons and more, why we want to review trusts. Okay, one, have you acquired new assets? Let's get them in the trust. You're picking people to serve as trustee, to manage the assets if something happens to you, potentially guardians for your children. There could be shifting family dynamics. People move away. Maybe the people you choose to serve now are not the people that are the right choices when the kids are teenagers or when you're older, whatever. That needs to be revisited. Change in laws. The estate tax exclusion changes. You might need to plan around that, okay? And then evolution of priorities. You know, maybe when your kids are little, you want to make sure that there's everything there to support them. But maybe if your kids are grown and they're doing really well, maybe all of a sudden you want to change your beneficiaries to charities that you support, or to, you know, the possibilities are endless as to why you need to review them. And one of the things that I do with my clients is every 3 years we check in. We look at your asset inventory and update that. Are the people that you've chosen to serve in these roles still the people you want to serve? And, you know, usually 3 years in, it's, you know, it's pretty similar, but sometimes there's changes. And so we want to make sure that your plan always works when it's needed, right? We don't want to create a trust and then have it not actually do the thing, or create guardianship documents and not have them work the way they're intended. Let's see, we can go to the next slide. Okay, so planning for incapacity. So while you're incapacitated, the person that you name as successor trustee can handle assets in your trust, okay? But there are assets outside your trust, and you know, your retirement and life insurance, for example, that don't go in your trust, and just all sorts of other things that are, you know, in your own individual name as opposed to your trust. You also want to have what's called a power of attorney, or a durable power of attorney. And I typically recommend that the person who's serving as trustee is also the person who serves as your agent. So they wear their trustee hat when they're dealing with trust assets, and their agent hat when dealing with non-trust assets. So the left hand knows what the right hand is doing when it comes to any kind of legal or financial decisions if you're incapacitated. Also medical decisions, right? Who is going to make medical decisions for you? And I bring it up because do you guys remember the Terry Schiavo case back in the day, where it was that young woman had a heart attack, and her husband and her parents were arguing about whether to take her off life support, and it was all over the news, and it was so heartbreaking. Had she actually had an advanced health care directive naming an agent, none of that would have happened. So what we do is we name agents to make healthcare decisions for us, and we identify what our wishes would be. Would you want to be kept on life support? Would you not? Do you want to donate organs? Do you not want to do that? And then we customize. You know, some people have very specific ideas about all sorts of things around that, and so it's really important. And you know, people often think of the financial piece of it as being, the biggest thing, but imagine the burden that you would leave to your loved ones when it comes to your life, not knowing what your wishes would be, right? Think of all these things as we do them as a gift. I call estate planning, I think it's on the cover of my website, an act of love, because it is. That's what it is. Again, it's about the people we love. If you don't have these documents in place and you're incapacitated, your loved ones will have to go to court and get what's called a conservatorship. So people call it like a living probate and a death probate, but it's, they basically have to go to court, petition the court to become that person for you. It's thousands of dollars, but you can just fill out these documents ahead of time and identify what those things are. So this is all, another part of the estate plan, and we can go. Okay, and for those who have kids, who know people with kids, this is just so important to me. So traditional estate planning, you could name long-term guardians in a will, and that's a good start. But the problem is a will only comes into play if you pass away, and not if you're incapacitated. So I do a whole, we call it a kids protection plan, a combination of documents and some other things that really make sure that there's as airtight planning as possible when it comes to making sure your kids are always in the hands of those you love and trust. So one of the things I also do is we name short-term or emergency guardians. For a lot of people, our families, the people that would take our kids if something happened long-term, may not live close by. Or even if they do, maybe they're traveling or stuck on the 405 or something, right? We want to name people who live close by, neighbors, babysitters, friends, community members who the kids could be with in the event of a traumatic situation. The last thing you'd ever want is for your kids to be taken out of the home into protective custody in a traumatic situation. Like I get physically ill when I think about that. And so think about somebody that your kids are close to and having that person have legal authority. And then of course we name long-term guardians and in a standalone document, so it's not in the will. For some people, they have people in their lives that they would never ever want to be raising their children. So we can do what's called a confidential exclusion of guardian. We identify the person, the reasons why we don't want them serving, we seal it, and we say it's only to be opened up in the event of a contested guardianship. And then we also do powers of attorney for the kids. So medical power of attorney, if the parents could not make medical decisions for the children, we allow the short-term and long-term guardians to make medical decisions, stand in the parent's shoes to make medical decisions on behalf of the kids. And then I also do this other power of attorney. So from the time there's a tragic event to the time that a judge would actually legally appoint somebody to serve as long-term guardian, there's a gap in time. And so this other document is intended to fill that in and give the people that you name as long-term guardians the ability to, register your kids for school or do all the things that parents or legal guardians can do, okay? And then I also give parents little wallet ID cards. So the emergency contacts are listed on there. So in the event you're in an accident or something, and by the way, I was in a pretty bad car accident. I'm so grateful to be here in December. And it's just a reminder that things can happen in an instant. As healthy as we are, as wonderful drivers as we are, it really can change. And so this then just, the authorities would know who has legal authority to be with the kids in the event of an emergency. We can go on. Okay. So this is my favorite part of the whole planning process. While I love legal documents and all, I really love people. And to me, no estate plan is truly complete without the things that are most precious to us, our most priceless assets, our memories, our stories, our hopes and dreams for our families. And so what I do when we get the trust done, the funding's done, I do recorded interviews. I send a whole bunch of questions to clients, and they get to choose the questions that resonate with them most. And then we do an interview, and it's a very conversational, low-key, I might need to hire you to start doing them more polished. But it's just a way to really share, and it's not a you're gonna watch this when I'm dead. It's more like we are capturing this moment in time. And I do, I mentioned the 3-year reviews. I give clients the opportunity to do another short interview at the 3-year mark. And so the idea is that you can build a legacy library. The idea is that hopefully one day you'll be, eating popcorn with your grandkids, watching these videos. So it's a really special, I love it. I feel so connected to my clients at the end of this, and I think it's a really nice way to kind of punctuate the process. And then the other thing I do for parents is I really encourage them to fill out worksheets to both their guardians and their trustees. So to the guardians, what are your parenting philosophies? What do you value? What family members do you want the kids to see? What places do you want them to travel? What kind of education do you want them to have? And then to the trustees, what is your priority with how the assets are used? Public education versus private education. Do you want to fund travel, starting a business, all of that? So my hope, and as bringing it back to what Kim said earlier, my hope is that as you go through this process, you are actually stepping more into the shoes of who you are as a parent in this case, because you're like, oh, I really want my kids to go to a museum. Well, we haven't been to a museum in a while. We better get to that museum, or it's very intentional. It's really about who you are and sharing that. And so I love that exercise, and I'm always happy when parents do fill these out. I offer free 30-minute consultations, so I really invite you to, if you're interested, you want to, I'll stick around and happy to answer questions after we're done. But if you want to chat more, I welcome you to do that. Share that with people. I love, being able to offer more information. So with that, I will hand it over. Thank you so much.
So